to the Sheriff's Department. I hope to bring that same new energy to the District Attorney's Office.
You know, there are a lot of things to change when you take over an administration. I'm not Jerry Shea, and certainly Jerry Shea knows that. Jerry and I haven't agreed on everything, but I've instituted his policies because he's the elected. You folks elected him, and that's what we've done. I agree that you have to be very open. But what we need to do first, and some of these things are actually already in the works. I mean, they might happen faster than you expect. Our sentencing guidelines will change, based first on a memo that I drafted last July. And we have to change them because of realignment. That memo may be published before this election from the elected District Attorney Jerry Shea. It may not. We need to reorganize our office. I told Jerry 10 years ago we need to reorganize our office. He still made me Chief Deputy 6 years ago. But these are all things we need. We have a very disproportionate workload in our office, and it creates a lot of tension. We have 6 people doing 15,000 misdemeanors a year. There's something wrong with that picture. That needs to be changed. We'll change that by instituting a diversion program, a comprehensive diversion program for misdemeanors so that we can. That's something that I've been pitching for more than 5 years. That will happen quickly if it doesn't happen before Jerry steps down in January. So there are many things to happen. Reorganization, diversion, sentencing guidelines. All of these things will change, and all of them will change, though, with input from everybody in the office. Not just the deputy district attorneys, but staff.
Thank you. We're getting down to the last few questions, and we'll begin this one with Tim. Given that realignment has caused jail crowding, how would you balance alternative sentencing that does not entail jail time with public safety?
Well, first, the alternative sentencing is going to be done for those large, or that majority of crimes that are not serious or violent. And they're going to be, alternative sentencing has to be appropriate to public safety issues. So typically we're talking about drug and alcohol issues, even at the felony level. There are lots of crimes that actually do not have the same threats to public safety. And realignment has instituted lots of things to help us do that. The probation department is using diagnostic tools. I've been working on realignment for 2 years. I actually think we need more diagnostic tools. San Diego is one of the leaders in this area, and I think we should be using more of their tools. But we will weigh those things in much the way we have when we started with drug court back in the 90s. We look at those cases that aren't a threat to the community. We look at those cases where people have the potential to not reoffend, where we can use our resources to actually make the future expenditure of resources reduce. So that's the way you go about it. You simply identify those things that are appropriate for alternative sentencing. For those things that aren't, you have to be much more serious, and you have to be much more aggressive. And so it's a weighing and balancing, and that's something that, frankly, it takes a lot of experience to understand and to know how to weigh and balance. You have to have prosecuted all of those kinds of things. You have to have worked on those programs with probation and the sheriff. Thank you.
Yeah, realignment was a deal that happened a couple years ago when the state changed the rules of the game, and they sent a lot of people that used to go to state prison for non-violent, non-sex offender types of cases to our county jails. And so by the very virtue of that, these folks are not the worst of the worst. They're people that are now eligible for our county jail, that are committing thefts and that are committing drug and alcohol cases and that sort of thing. But the problem is we've had a 20% growth in our jail population since realignment was instituted. I've been out to the jail recently. I had a tour, and out of the 680 people that were there that day, there were well over half of them were on mental health medications. And so mental health is also an issue with this population. And so we have to come up with some creative ways of dealing with non-violent, non-sex offender jail population. We're already at maximum capacity. We can't take any more at our county jail. One of the things that I talked about already, was that Veterans Treatment Court. It's identified a population group that could have otherwise gone to jail, and instead we peeled them off, and they have a high accountability. They're in court. twice a month, and they have a veteran mentor that helps them get through the program. And it's very, very effective, and they don't come back through our courts time and time again after they've completed that program. I'm proud of that. Another thing that I'm talking about is why don't we look at maybe for the nonviolent offenders, opening up some of these barracks out at Camp San Luis Obispo that haven't been used. Expand our work release program so that those folks that aren't going to be a risk to our community, they can go to work during the day so they can continue to pay for their families, and then they get residential oversight at night without a whole lot of burden on our correctional staff.
Thank you. If a batter is a veteran, which court would they go to for trial? Ordinary court or vet court? And Tim, we'll start with you.
Well, the answer is it really depends. And that is, those who are eligible for Veterans Treatment Court have to have certain conditions, they have to be documented, and they have to have it as a result of their service. In other words, you can't just be a veteran and go to Veterans Treatment Court. There has to be some relationship between the condition that you've got. And that was one of the things I think early on that Dan misperceived as reluctance. We have to set pretty serious guidelines. And one of the absolute rules of Veterans Treatment Court is that you have to be probation eligible. And some of the sticky issues early on, for instance, was one of the first members of that program actually had initially been receiving a sentence to state prison. And that state prison deal was later changed. And so that actually was in violation of that statute. So you have to be careful. You have to make sure that someone qualifies under the statute to begin with, and whether or not it's the appropriate court for them to be in. As it stands now, they should be prosecuted in the court that they actually appear in, and then they are only sent to Veterans Treatment Court for their probation term, like other treatment courts. That's where they get their treatment. So that's the answer to that.
But the prerequisite for that question is we have to start a domestic violence court, and that's what I'm going to do. I'm going to work hard with the courts and with our other partners to make sure that we address that problem. And as far as which court would they go to, I'll tell you the Veterans Treatment Court is a fantastic model for dealing with the underlying conditions that are what's causing the person to get involved in crime, whether it be violence, drugs, or alcohol. If you think about it for a minute, if you've been completely fine here in the States when you were recruited in the military, and you went off to Afghanistan, and you saw 10 or 12 of your buddies, your fellow Marines, blown up in front of you or killed in combat, and you came back, you're going to have some psychological scars, some of those invisible wounds of the battlefield that we might not know about, don't talk about. That's going to cause relational issues. And so the men and women that are coming into our Veterans Treatment Court, whether it be for domestic violence or whether it be for a drug and alcohol issue, the reason they're having problems resolving issues in their family is because of the PTSD that they went through, or perhaps a traumatic brain injury, something like that. And so I would tell you that it's hard to answer that question without knowing the specific case, but in most cases, I would tell you, if we had two of those courts, it would be the Veterans Treatment Court. What would still go along with it, though, is the requirement that they do a 52-week batterers intervention program. That's required in every domestic violence case. And so even if they're in Veterans Court, they still have to do that. But the keys to success, the reason why these veterans don't come back in through our door again, is because they have a veteran mentor that's been assigned in high accountability and the structure that a military person responds very well to.
Thank you. Dan, I'd like to start with you this time. Is it important to have major felony trial experience as the district attorney?
Sure, and I've got that. My opponent likes to undermine it, but I do have it. I've tried 3 strikes cases, sent people to prison for life, and the cases that I'm handling, the child sexual assault cases that I'm handling are cases that, again, my opponent hasn't had experience doing it. Is that a big deal? No. The qualifications to be district attorney are 1, that you have a license to practice law in the state of California, and 2, that you have the confidence of the people in that county that you can lead. I believe I've got the confidence of many people right now. I'm hopeful to have the confidence of a majority of the people on June 3rd. And I will tell you that it is important to have the type of experience where you understand what's going on in the courtroom. But you don't have to have tried every single case She's, you know, my opponent hasn't tried every kind of case. You don't have to have that to be a district attorney. You have to be someone who can work well with people. You have to be someone who cares very deeply about the safety of our community. You have to be a person that can pull people together, that when we're faced with the homeless issues that we are right now, that while we can't make a decision, we can be a part of the conversation of how to address that issue for our community. And so what's most important is not handling death penalty cases in trial, because as DA, you're never going to do it. In fact, the DA doesn't give personal trial advice very often at all. It's very, very rare. So you're not a trial trainer either, which has been alluded to. The people that we have in the office, the 23 deputy district attorneys that are supporting me, they collectively have 450 years of experience. Those men and women will continue to serve and will continue to prosecute their cases vigorously, and I'm anxious to lead them.
Well, Dan's right. There's a lot of collective experience in the office. In fact, those deputy district attorneys, all of that collective experience he's talking about, the vast majority of those 23 deputy district attorneys have 2, 3, and 4 times Dan's experience in prosecutions. That's a fact. And that experience is something that makes them actually more knowledgeable about their caseloads. They've had greater caseloads. They've done many more jury trials than Dan has. Dan can't set the standards because they will set the standards, because they know the value of a case, because Dan can't. Dan keeps alluding to the trials he's done, and I'll make sure that I save some time for him so he can identify. I know of 1 felony jury trial he's done. And if he's got other felony jury trials in all of the areas that he's talked about, I think he should identify them. I think he should identify them for everybody in this room to know what the name is and what the charges were and what the outcomes were. Mine are well documented.
Thank you. Dan, if you'll go first, please. Will you continue to support inter-county law enforcement agencies to fight gangs and drug trafficking in our county?
Absolutely, and it is critical that we do that. We have a great gang task force right now that's primarily led by the Sheriff's Department. We have a DA investigator that's assigned to that team, and we have 2 prosecutors in our office that part of their assignment is to prosecute the gang crimes. It's absolutely critical that we reaffirm our commitment to having a gang task force. But we can do some things a little bit differently in terms of tackling the gang problem. Instead of just relying in the gang task force folks that are focused on it with the specific expertise, we need to widen the net, because right now it's early. The gangs are trying to make inroads. We've had an uptick in the serious and violent crimes that the gangs have been committing, 13 last year, 4 in the first 2 months of this year. And what's important is that the men and women that are on the street, the patrol deputies and the patrol officers, need also to be equipped with the right training to be able to identify in the field. Because if you think about it, the men and women that are on the streets are the ones that are interacting with most of the people and citizens in our community. When they spot it, then they can fill out a field identification card, track the gangs, so that we can build a case so that we can prove a gang enhancement later on. I also want to enhance our gang enforcement by being out in the community, talking with folks in every city and town and county area that's seeing any kind of a pattern of gang activity, to where we can educate our community. They know as well how to spot the signs of gang activity. They can then report it. They know how to do it in a way that will protect them, but in a way that together we can solve this gang problem. As far as the narcotics, absolutely. We need to go vigorously in our prosecution against anybody dealing hard drugs, as I said earlier, like heroin to our kids.